objecting to somebody's exemption claim in a Chapter 7 bankruptcy or in a Chapter 13 bankruptcy, that deadline for a trustee or any other creditor to object is 30 days after the date first scheduled for the meeting of creditors in the bankruptcy notice. If nobody objects to that exemption claim, then at that point the property is exempt and it is no longer property of the bankruptcy estate. It reverts back to the debtor. It is no longer under the jurisdiction of the federal court. Property of the estate in Chapter 13 bankruptcy cases includes all those legal and equitable interests of the debtor owned on the day that the bankruptcy case is filed, and in addition to that, all post-petition earnings, because those earnings and that income are part of what makes that Chapter 13 repayment plan work. Now, the Chapter 7 debtor, his post-petition wages are not property of that bankruptcy estate, and there's a big distinction there. So, going back to what the automatic stay does or does not do, under Section 362BC, even though the income of a debtor in a Chapter 13 bankruptcy is property of the estate that we shouldn't be messing with, in Chapter 13, if there's an existing withholding order or something like that from the court or an administrative agency or governmental agency, that can continue. That is okay. That is not a violation of the automatic stay, even though it is property of the estate. Now, a domestic support obligation is pretty much what it sounds like. And there's a definition in the Bankruptcy Code at 101, Section 101, 14A. A domestic support obligation is a debt, and this is a brand new definition. It didn't exist prior to 2005, but it is a debt to a spouse or a child in the nature of alimony or support, and that was established by a court order, divorce or separation agreement, and doesn't matter whether that was established before the bankruptcy was filed, on the date the bankruptcy was filed, or after the date that the bankruptcy was filed. So this new definition of a domestic support obligation is much broader and wider than it used to be under the old bankruptcy code. Now, on page 5 of the outline, I've listed some things there about domestic support obligations and payment and collection issues that are now different under the new bankruptcy law that fairly significant. All of these child support or alimony claims are DSOs, as long as they fit within that definition. And a DSO enjoys a first priority in distribution of assets collected by a Chapter 7 bankruptcy trustee. A DSO also enjoys a first priority in payment under a Chapter 13. Trustees are allowed to take their expenses out of any assets that they collect and liquidate for distribution to creditors. But under the prior law, the bankruptcy code section that identifies the priority of distribution of money to creditors, listed like 1 through 9, child support and alimony creditors were ranked number 7 under the old code. They are now ranked number 1. That's a significant improvement. Normally, in any kind of a bankruptcy case, if your client says, comes in and says, "Oh, I've got this notice and I've got this proof of claim form, what do I do with that?" In any kind of a bankruptcy case where there are assets to be dispersed to creditors, that's always true with a Chapter 13 because it's a repayment plan. It's only sometimes true with a Chapter 7 bankruptcy, only if there are assets available that are not exempt that a trustee can liquidate. Then if your client, who with child support or alimony or a property settlement or something like that, if they've received notice of the bankruptcy, normally if there are assets to be dispersed, they'll also get a proof of claim form. There's a deadline for filing that proof of claim form in every bankruptcy case. You want to make sure you watch for that. But they do need to file that proof of claim in that bankruptcy in order to receive that distribution. If you are, as their attorney, are not part of the electronic filing system, you can't do it. Your client can fill it out on her own, sign it, mail it up to the bankruptcy clerk's office, and then it's fine. But if you try and do that, they're going to mail it right back to you because all attorneys have to, in South Dakota, do the electronic filing. Interestingly, I mentioned, with our state exemption laws, there is one provision under the exemption laws that says that these exemptions aren't available to people who owe child support and things like that. In bankruptcy cases, assets that are normally exempt can lose that exemption if there's a past due support obligation. And for example, if some jerk files a Chapter 7 bankruptcy, and he's got some fairly significant assets, and he's able to claim an exemption in those, and he owes back child support of $10,000 or something like that, and that back child support is not being paid, it's due, it is an arrears that he's not addressing, then the bankruptcy trustee can override those exemptions that he has, take his property, liquidate it, and make a disbursement to the child support creditor. That is also codified in the bankruptcy code under section 522C, which states that the court and trustees can override those exemptions for people who are behind on child support. So this new bankruptcy law basically did put Chapter 7 trustees into a position of being able to really go after child support. And it didn't make a lot of Chapter 7 trustees happy that they've become child support collection officers now, but that's kind of the way it is. But as long as they get to take their commission out of selling assets, then they're kind of happy because that's how they make money. Chapter 13 reorganization plans cannot be confirmed unless the debtor is current on his post-petition child support obligations. If there's a failure to pay those DSO obligations during that Chapter 13 repayment plan, then that bankruptcy case can be dismissed or converted. And whether and require a creditor to come in and file a motion to dismiss or convert. And whether it's preferable, it's up to the bankruptcy judge to determine what's in the best interest of creditors. Whether a bankruptcy case should be, a Chapter 13 case should be dismissed or converted to a Chapter 7. But in a situation where child support is not being paid, and maybe one of the reasons why this guy filed Chapter 13 is he's got a bunch of assets that he didn't want to lose in a Chapter 7. Now he's not making the support payments. His child support, the ex-spouse now can come into bankruptcy court and ask the court to convert that case to a Chapter 7. Then, if that happens, all those assets can be liquidated by that bankruptcy trustee and then dispersed to your client who's owed the child support. That wasn't true before. As opposed to just having that bankruptcy case dismissed, which that creditor could ask for. Under those circumstances, then the bankruptcy's over with, this guy's got all his property back, and you're trying to collect child support against him, then you got to go to state court and you got to do a bunch of really busy stuff. And under these circumstances, it's sometimes easier just to have the court convert it to a Chapter 7 and have the trustee liquidate those assets, and all your enforcement options are basically taken care of you by a bankruptcy trustee. That is new. DSO arrearages in a repayment plan have to be accorded a first priority. When people file Chapter 13 bankruptcies, if they owe past due child support, that's going to get paid first before the other creditors are going to get paid. And that, again, is a first priority. If there is a child support arrearage in a Chapter 13 case, but that debtor is paying what he's supposed to be paying pursuant to a court order, for example, you've got to pay $300 a month in ongoing support, plus $50 a month against this $10,000 arrearage. As long as that debtor is complying with that DSO, then he's not in default. And even though he does have past due child support, if he's making those payments, then he's in compliance with the bankruptcy code. Not going to lose these exemptions, not going to get his plan dismissed or anything like that. Same thing for a Chapter 7 debtor. If you're in compliance with a DSO, then that bankruptcy case is going to go through without too many problems. Under the new law, trustees now have to give special notice to DSO creditors when they see a Chapter 7 bankruptcy case that lists one of the debts being child support or alimony owed to somebody. Before they can close that bankruptcy case, they send a notice to that creditor who's owed child support or alimony, tell him the debtor's name and the debtor's address, where he works, the address of his employer, phone number, and all this other stuff. Another thing that didn't make the trustees very happy, but that was another aspect of this new law that really threw the bankruptcy court into the business of collecting child support. And before a repayment plan debtor, a Chapter 13, can get their plan finished, dismissed, or excuse me, discharged at the end, they do have to certify to the court that they have been current on all of their post-petition payments under a DSO. A lot of you have heard about, in bankruptcy cases, preferential transfers, when somebody transfers money or property to a creditor and then files bankruptcy. Sometimes bankruptcy trustees can go back in time up to 90 days or up to a year sometimes and take that money away from that creditor and bring it back into that bankruptcy estate because that creditor was preferred over the other creditors. That is a preferential transfer. And it's common and it's routine in larger types of bankruptcies and certainly in reorganization bankruptcies. But DSO payments are not recoverable as a preference. So even though somebody might get a big chunk of money from an IRS offset, payable on their past due support that they've been not able to collect otherwise, if their ex-spouse then files a bankruptcy, that payment will not be considered to be a preference under the new bankruptcy code. All right, now I'm going to talk a little bit about non-dischargeability. The good news is that all DSOs are non-dischargeable. You never, ever have to worry about that. As far as property settlements, that's a different animal. The code sections in bankruptcy that govern discharged debts in bankruptcy are Section 523 for all bankruptcies, and for Chapter 13, Section 1328 of the Bankruptcy Code says what debts are discharged in a Chapter 13 and then incorporates those 523 code section list. There's about 19 non-dischargeable debts in a Chapter 7 bankruptcy or any kind of a bankruptcy. But the only two that we're concerned about are the ones that are covered under Section 523A5. And under that section it says debts that are not discharged are DSOs, period. There's no description, there's no nothing. The definition of the DSO is in Section 101 of the Bankruptcy Code. 523A5 of the Bankruptcy Code says DSOs are not discharged, not ever. Property settlements are covered under 523A15 of the Bankruptcy Code. And under the old law, prior to the amendments in 2005, when your client received a notice that their ex-spouse had filed for bankruptcy and trying to discharge the joint marital debts that they had and trying to get out from under paying a property settlement, your client had to do something under the old law. And you had to file a complaint objecting to discharge of that obligation within 60 days after the meeting of creditors. In a typical bankruptcy case, that's 3.5 months or so. So, and then by filing that objection, you've got to pay a $150 filing fee. You have to hire an attorney to get that pursued. And then there could be a hearing, a trial to determine whether that obligation is going to be discharged or not, and the bankruptcy court had to go through a balancing test. Lucky for us here in South Dakota, the bankruptcy judges that we've had have almost routinely, not let anybody get out of their divorce obligations. So those adversary proceedings, although they were necessary in order to preserve that objection, you were usually successful in doing that. Now, under the new bankruptcy code, that deadline is gone. If you've got a client who has a property settlement owed to them, they don't have to file anything within any deadline in a Chapter 7 or a Chapter 13 bankruptcy, and that is really good news. So paragraph 5 covers DSO obligations. Paragraph 15 of 523A of the Bankruptcy Code covers property settlements, and they are non-dischargeable, period. Even the state court has concurrent jurisdiction to make a ruling that a debt has not been discharged in bankruptcy if it's a DSO or a property settlement. Now, usually in our divorce agreements, when we put together a hold harmless clause where you're signing dad's going to pay these debts over here, mom's going to pay these debts, and there's usually a sentence or a clause in there that says you're going to hold harmless the other spouse for payment on these obligations. And what is actually being done here is we're saying that this credit card debt, I'm going to pay the MasterCard debt, I'm going to pay the Bank of America debt, and then my spouse will pay the other ones. There has been some suggestion that there might be a problem with that as far as dischargeability in bankruptcy. Now, what it says under 523A15 is that a bankruptcy discharge does not discharge an individual debtor from any debt to a spouse, former spouse, or child of the debtor. And I italicized that on page 6. So if you're agreed to pay the MasterCard debt or the Bank of America debt, is that really a debt to a spouse that is accepted under the Bankruptcy Code from discharge or not? And there is at least one commentator who has suggested otherwise, and that maybe somebody can escape through bankruptcy and get those debts discharged and get that obligation of the spouse discharged. I don't know if that would ever happen in South Dakota, but it's probably not a bad idea to, when you put together a debt division in a divorce stipulation, throw some extra language in there that the plaintiff doesn't timely pay these obligations as set forth in this agreement, then that obligation shall in like manner be owed to the defendant directly as additional support or property settlement or something like that. So it's not terribly important, but it is something to think about. Again, whether a debt is in the nature of alimony or support or as a DSO is a federal court question because it's a federal definition. And there are some circumstances where there is some confusion as to whether the obligation imposed by the divorce decree is in fact a DSO or something else. In most Chapter 7 bankruptcy cases, that is not particularly important. In Chapter 13 cases, it can be. Part F, page 7, bottom of the outline, Non-DSO domestic obligations are dischargeable in Chapter 13 bankruptcies. DSOs are fine, but when it comes to a property settlement, a debtor can file a Chapter 13, and even though that plan does not provide for full payment on that property settlement obligation to the former spouse, it will be discharged as long as he's otherwise in compliance with the bankruptcy code. So I don't know why they made that difference in Chapter 13, because Chapter 13, it used to be that you could get out from under almost any debt in a Chapter 13 bankruptcy. Debts incurred by fraud, misrepresentation, theft, embezzlement, didn't matter. You had a super discharge in a Chapter 13. You could file a Chapter 13 and have all these nasty types of debt obligations, and as long as you completed that Chapter 13 plan, you get a discharge, and they're gone away. And then in 2005, when they amended the code, they included all these additional provisions now under Section 1328 that says, when you get a discharge in a Chapter 13, it does not discharge all these other debts. It lists a whole number of them from Section 523A of the Bankruptcy Code, but it doesn't list 523A-15, which is a property settlement. So that's something to keep in mind. Page 8 of the outline, I basically set out some scenarios for a couple of losers named Jack and Jill. And that just kind of basically lets you know what is discharged, what is not discharged in a typical bankruptcy when we're dealing with people who have gone through a divorce and then subsequently one of them files for bankruptcy. Interestingly enough, you know, in the first hypothetical where Jill has filed for bankruptcy because she has not been paid child support from her ex-husband and she's broke, and let's say, for example, she's owed $10,000 in back child support, that's an asset of hers that exists on the date of the bankruptcy. It's a claim that she has, and it far exceeds anything that she can exempt under the exemption laws in South Dakota. What happens to it? And actually, this was one of my cases that a bankruptcy trustee tried to get that child support money as one of her assets and administer it in her bankruptcy and pay it to her general unsecured creditors. In the very back of the outline, there is a citation to a case that decides that question. In South Dakota, the bankruptcy judge has said that child support that exists on the date of a filing of the bankruptcy is not property of the estate. It's not owned by that person who's filing bankruptcy. Instead, it is held or owned in trust for the benefit of the children. And the court was able to come to that decision based on looking at South Dakota family law decisions going back several decades. Now, that is not true with respect to a property settlement. If this same gal, Jill, files for bankruptcy and she is owed money that she was supposed to have been paid by her ex-husband from the divorce, and it's a property settlement, that's one of her assets. And the trustee in bankruptcy can go after that ex-husband and try and collect that money to use to pay her general unsecured creditors. Likewise, if the opposite scenario happens and Jill is not filing bankruptcy, but Jack is, neither his DSO obligation to her nor his property settlement obligation to her is going to be discharged. So he can decide, well, maybe I should just convert to a chapter, maybe I shouldn't do this chapter 7, I could move over to a chapter 13. In a chapter 13 bankruptcy, he would have to provide for full payment of that child support obligation to his ex-spouse, but he could end up discharging the property settlement portion of his divorce decree by going through the chapter 13. I put a little caveat in there on page 9 of the outline that, you know, bankruptcy plans that are put together by bankruptcy lawyers are supposed to be in compliance with the bankruptcy code. They're not supposed to have any provisions that are in violation of law, but sometimes people sneak things in. And a confirmation order in a bankruptcy case is a final order, and it determines finally the rights and obligations of the debtor and the creditors, and they are bound by that confirmation order. In a recent case from the United States Supreme Court that was just decided a couple of years ago, there was a Chapter 13 case where this gentleman had put some language in his Chapter 13 plan about discharging his student loan obligations. Student loans are a non-dischargeable debt. So in this Espinoza case that I have listed here, and I won't bore you with the procedure that was involved because it's pretty lengthy, basically the Supreme Court said that, yeah, student loans are non-dischargeable in bankruptcy. But there was some language in this plan that says we're going to discharge them anyway. And you didn't object, you got timely notice and all this other business. Yes, we know that lawyers aren't supposed to put unlawful things in bankruptcy plans, and judges aren't supposed to confirm bankruptcy plans that have unlawful provisions. Nevertheless, the Supreme Court let this case stand. It's a really strange decision. So there's a possibility that you could have something in a Chapter 13 bankruptcy case that your client brings into you where there's something in that plan that maybe is some objectionable language. You do want to take a look at those things if you're representing somebody who's trying to collect their child support or their property settlement and their ex has filed a Chapter 13.